Hey everyone, it's your man Dr. L. Thank you so much for checking out this episode. Make sure you hit the like button, subscribe, share, all that kind of good stuff. If there is a story that you have for me to speak about, some of the entire clip, and then we can, have an investigative breakdown of it to the best of my abilities, given the information that I'm presented at that particular time. All right, so now we're going to jump into it here. We're going to look at the state's attorneys. They cleared the Florida officer and the use of force in the traffic stop arrest that went viral with William McNeil Jr. If you recalled, he was the brother who claimed that had excessive force used upon him, was stopped for no reason or for a very minimal reason. The stop went bad, was assaulted, et cetera, et cetera. Now, I got to be honest with you. I did not. I'm not. There's got to be some type of justification. There's got to be some type of uh, correction, some type of discipline that should come of the officer's way. That is what I'm not clear about, and maybe we'll read it in this report. I have not read this news article yet, and we're going to read through the state's attorney's their 16-page letter of recommendation for in clearing the officer and the use of force, which I got to be honest, I find to be very, very concerning. Let me see here. Let me close some stuff here. My internet is kind of slow, so we'll close some stuff. All right. Maybe that'll help there. All right. Let's see. Let's close some more stuff here. Make sure everything is nice and smooth. All right. All right. So here we go. We're gonna read this report here. We'll put it added to the stage. And this is the report here. State's attorney clears Florida officers' use of force and traffic stop arrest that went viral. 16-page investigative report. Why does this do this? Come on. Provides new details about Will McNeil's case. All right, so here's him as he's about to be assaulted here. Jacksonville, Florida. The state's attorney's office, SAO, and this comes from clickorlando.news.com. Clickorlando.com news. The state's attorney, SAO, on Wednesday released a 16-page investigative report revealing new details surrounding the arrest of William McNeil Jr., the man whose controversial confrontation with the Jacksonville Sheriff's Office that was captured on video during a traffic stop drew national attention. According to a story by our sister station, WJXT in Jacksonville. The stop of McNeil, a college student who was pulled from his car and beaten by officers, led to an investigation. Wow, that was a statement right there. And beaten by officers led to an investigation and calls for motorists to consider protecting themselves by placing a camera inside their vehicles. We'll play the video here in a second. McNeil captured his February traffic stop on his cell phone camera, which was mounted above his dashboard. It offered a unique view, providing the only clear footage of the violence by officers, including punches to his head that can be seen clearly in body cam footage released by the Jackson Sheriff's Office. According to the SAO's report released Wednesday, Officer D.J. Bowers stopped McNeil for traffic violations, including driving without headlights in inclement weather and not wearing a seat belt. You can read the full report here. We will read the full report. New information in the report revealed that the stop came after McNeil was seen at a house that was under active surveillance for drug activity just before 4 p.m. on February 19th on West Palm Avenue. It was daylight and no rain could be seen in McNeil's video or body cam videos shared by Jackson Sheriff T.K. Waters, calling into question Bauer's original reason for pulling McNeil over. Wow, this is okay. This is what this article says. If you watch the video, you can clearly see that at some point in time within the recent past of the video that there was raindrops on the car, but okay. The report said once McNeil stopped, he refused to provide his license, registration, or proof of insurance, which you must do, refused to exit the vehicle, which you must do if the officer asks you to do it, and failed to follow lawful commands 12 times. McNeil's refusal to provide his identification, registration, and proof of insurance, followed by his refusal to exit the SUV, show his hands, and obey the officer's orders, created a dangerous situation for all involved, SAO investigators wrote in the report. Instead of getting out of the vehicle when Bowers ordered him to, McNeil shut and locked the door, and Bowers called for backup. Following a tense conversation between McNeil and one of the backup officers, Bowers broke the window. According to the report, Bowers then used 2 instances of physical force, an open hand strike and a punch, to gain compliance during McNeil's arrest. The SAO said that open hand strike, which was shown in the screen grab from the video, served a legitimate tactical purpose to get McNeil out of the vehicle and to show his hands, which McNeil did after the strike. Bowers' arrest report for McNeil did not mention the first strike in the face. When asked why he did not report the hit in his response to resistance report, Bowers explained he considered his use of the distraction strike as a tool and did not consider it as a deployment of force, according to investigators. Wow, that's a new one for me anyway. Officer Bowers explained his credible considering Officer Bowers' explanation is credible, considering his stated training and the fact that he wrote a responsive resistance report memorializing all his closed fist punch to McNeil, the report states. News for JAX crime and safety analyst Tom Hackney said he expects Bowers' omission of the strike to come up in the agency's internal affairs investigation. You want a true document of what happened during the incident, Hackney said. You want that to coincide with what the video shows, what the body-worn camera shows. The SAO said it confirmed that this technique is taught by the Defensive Tactics curriculum at the Northeast Florida Criminal Justice Training and Education Center, also known as the Academy. In a July 21st interview with JSO Integrity Detectives, the day after the video went viral, Officer Bowers, accompanied by an attorney, described the distraction strike to the face as a tactic he was taught during his time as a narcotics officer when conducting the arrest. Gosh, I lost my place here. Arrest of a vehicle's occupant. Officer Bowers said his intended purpose in using the distraction and using this tactic was not to injure McNeil, but to distract him so that he could take control of him. Officer Bowers said he believed that he was at a tactical disadvantage because McNeil had essentially barricaded himself in his car. Bowers and another officer also said they repeatedly saw McNeil's hands moving down below the steering wheel and out of sight. The report noted that counsel for Bowers limited the scope of the JSO internal interview to the circumstances giving rise to Bowers' first strike. His counsel indicated that Bowers' written report spoke to this second strike and accordingly would serve as Bowers' official statement. The SAO said Bowers' second strike, a closed fist punch to McNeil's chin, happened during McNeil's arrest and was in response to McNeil's physical resistance. McNeil said he suffered a chipped tooth and a concussion during the interaction. McNeil was later found to have drugs in his pocket, drug paraphernalia in the vehicle, a large serrated knife at his feet, and was driving on a suspended license, according to report. The SAO said it's amazing to me that people do all this stuff. It's amazing to me that people do all this stuff. Drive around with suspended licenses and then have the nerve, the gall, and the audacity to fight with officers. You got drugs in your pocket. What are you doing, man? I mean, just but I know we're the wrong ones. We're the corrupt ones. Crazy. It's crazy. The report said Bowers' use of force was consistent with his training as a distraction strike and control physical resistance. And the state's attorney's office concluded the force was lawful and did not constitute criminal acts based on probable cause of traffic violations and drug-related surveillance information. When Bowers stopped the vehicle McNeil was driving, he had no idea who was driving the vehicle. He knew McNeil had just been at a house under surveillance for narcotics, and he quickly learned he was dealing with a non-compliant driver. Officer Bowers did not know what was going through McNeil's mind or what McNeil's intentions may be, the report says. McNeil, on the other hand, knew he was driving on a suspended license. He knew he had drugs in his pocket and drug paraphernalia in the car. He knew he had a large serrated knife at his feet, and for these reasons, McNeil also knew he would likely be arrested. No criminal charges against the officer would be pursued. The report also noted that what it called misinformation presented by McNeil at the press conferences. Specifically, McNeil said he was held at gunpoint for a mere traffic infraction, but the SAO said it was only after McNeil was under arrest And while officers were attempting to take him into custody, that an officer drew his firearm to provide lethal cover for the other officers. Bowers was placed on administrative leave pending the outcome of the JSO internal investigation, and it was immediately clear when, and it wasn't immediately clear when or if he would be reinstated. Court records show that McNeil was adjudicated guilty of resisting an officer without violence and driving on a suspended license. Drug charges originally made against him, along with citations for not wearing a seatbelt and driving without headlights in inclement weather, were dropped. McNeil is represented by civil rights attorney Harry Daniels and Ben Crump, who issued a joint statement following the release of the investigative memo. The investigative memo from Ben Crump or Harry Daniels, or both of them. The investigative memo from the state's attorney's office from the 4th Judicial Circuit is little more than an attempt to justify the actions of Officer Bowers and his fellow officers after the fact. Frankly, we expected nothing less, especially after the Sheriff Waters announced their conclusions more than 3 weeks before the report was issued. Since they are unwilling to seek justice, we will have to request the U.S. Department of Justice to investigate this incident and the Jackson's Sheriff's Office. Let's be clear, the state's attorney's office never interviewed William McNeil. They did, however, try to excuse the fact that the Officer Bowers failed to disclose his unlawful distractionary strike. They also tried to decriminalize Bowers punching Mr. McNeil outside the vehicle and completely failed to mention the officer slamming McNeil's face into the asphalt while he was under control and in custody. Furthermore, they ignored the multiple injuries, including a broken tooth, a concussion, and multiple stitches caused by the officer's use of force. Finally, the memo asks us to ignore our own eyes by accepting the officer's excuse that Mr. McNeil was reaching for a knife on the floorboard when he was never seen reaching for anything in either the body cam video or the video posted on social media. The simple fact is that the memo ignores what is exactly the kind of excessive force and false reporting that resulted in the United States Department of Justice indicting Camden County Sheriff's Deputy Buck Aldridge. It only further illustrates why use of force cases involving the Jacksonville Sheriff's Office need to be conducted by an independent agency that is beholden to either the Jacksonville Sheriff's Office or the state's attorney. Yeah. So here's the video if you have not seen it. So we'll watch it again here. There's a little bit of talking here, but
now unfolded into a viral video and an incident under investigation by the Jacksonville Sheriff's Office.
Putting his hands up, now folding his arms.
It's also raising serious concerns among civil rights advocates who say what happened to William McNeil Jr. was not only what started as a routine traffic stop has now unfolded into a viral video and an
that punch was a distraction strike, let me see if I can make this larger here. That punch was a distraction strike. Let's watch the distraction strike again.
What started as a routine traffic stop has now unfolded into a viral video and an incident under investigation by the Jacksonville Sheriff's Office. It's also raising serious concerns among civil rights advocates who say what happened to William McNeil Jr. was not only excessive, but criminal.
Can you pull that law up?
The February 19th stop began with officers pulling McNeil over for not having his headlights or taillights on during bad weather. But when McNeil asked to speak to a supervisor, things quickly escalated.
Instead of just waiting for a supervisor to come on the scene, they chose to escalate and break this man's window. That wasn't enough. He broke his window. Okay, now we can unlock the door and open the door. We can get him out. That wasn't enough. We had to punch him in the face.
Civil rights attorney Harry Daniels, who's representing McNeil with Ben Crump, says his client is still recovering from the injuries.
He suffered, had to get stitches, chipped tooth, concussion, closed head injury, and a short-term memory loss. And he's currently is trying to, or not currently, or actually is in counseling.
What is your reason?
Step out now.
All right. No.
McNeil was charged with resisting without violence and driving on a suspended license. Other charges against him were dropped.
I know it's still early in the process, but what's the first step your team is taking?
We want accountability. We want accountability. Listen, when I say that from the pits, bottom of my heart, of my soul, is that we want accountability. We want these officers charged. We want the officers charged who punched him. We want the officer charged who didn't stop the punch. We want all of them charged. We want the officers who stopped him illegally.
Alicia Hatcher, Channel 4, the local station.
I think it's going to be a stretch to get the officers charged who didn't stop the punch. I mean, how much time do you have in order to actually get stop this guy from punching? All right, so let's read through the actual report. Now, I got to say I disagree with a lot of this. I disagree with a lot of this. I mean, I understand breaking the window. I understand yanking him out. I understand all that. But I can't get with the punches to the face here. And what is not seen here, and you can watch other videos, I'm not going to pull it up now, is that there is an officer standing at the front of the car by the hood, the grill there, with his firearm trained on McNeil in case there's things go left really, really quickly. And it is dangerous. Let me be very clear. It is dangerous when you're going to extract someone from a vehicle. You don't know if they have a weapon secreted on them, underneath their seat, in their center console, et cetera, et cetera. So you don't know that. So yeah. All right. So let's get out of this. Okay. So this is the investigative memorandum, RE arrest of William McNeil Jr. That's the case number, dated February. This is when it occurred, February 19, 2025. State's Attorney's Office, 4th Judicial District of Florida, Duval County, August 13th, 2025. Here's all this. Let's see. All right, so we'll go to the executive summary here. We'll read through a little bit of this here. On February 19th, 2025, Officer D. Bowers of the Jacksonville Sheriff's Office saw an SUV parked at a house that was under active surveillance for drug activity. A short time later, he saw the SUV being driven without headlights and by a driver who was not wearing a seatbelt. Officer Bowers initiated a traffic stop. The driver, William McNeil Jr., opened his door, stating his window was broken, and asked why he was being pulled over. Officer Bowers explained the reason for the stop and asked for McNeil's license, registration, and proof from insurance. Again, you have to submit that for inspection most of the time, right? You can't just pull it up on your phone. An officer may accept that, particularly for insurance and registration, but you gotta submit your license, right? McNeil said no, argued the basis for the stop, and told Officer Bowers, "Call your supervisor." When Officer Bowers asked McNeil to step out of the SUV, McNeil again said no, and then slammed and locked the door. What started as a routine traffic stop quickly escalated into McNeil's arrest for resisting an officer without violence for failing to follow lawful orders. Despite being told 6 times he was under arrest, McNeil refused to get out of the SUV after 4 minutes of multiple warnings that he intended to break the windows. Officer Bauer broke McNeil's window and ordered him out of the SUV, but McNeil still refused to exit the SUV. While continuing to order McNeil out of the SUV, Officer Bauer struck McNeil in the face with an open hand strike and told him to show his hands, which McNeil did only after being struck. Okay, hold on a second here. Let's go back. Let's go back here. Stop screen share. Let's go back here. Let's play this. Let's see if we can slow it down here. All right, we're going to slow this down. We're going to slow this all the way down as much as possible. Playback speed, as slow as we can get it. Is this an open hand strike? All right. All right, it was an open hand strike. It was an open hand strike. Yep, it was. Okay. All right. He's struggling with an open hand strike. Present. Share screen. That was a distraction strike. It was very loud, which McNeil did only after being struck. Officer Bowers then unlocked the SUV door and unbuckled his McNeil's seatbelt, which McNeil had buckled after he was stopped. This is italicized after. Once officers pulled McNeil from the SUV, but McNeil actively resisted, continuing to argue and said no multiple times. In the struggle to gain compliance, Officer Bowers punched McNeil in the chin as officers arrested him. McNeil had drugs in his pocket, drug paraphernalia in the SUV, a large serrated knife at his feet, and was driving on a suspended license. Facts not known to Officer Bowers when he pulled McNeil over. The day after his arrest, McNeil pleaded guilty to resisting an officer without violence and driving on a suspended license. 5 months after his arrest and guilty plea, on July 20th, McNeil released a video he recorded of his traffic stop and arrest. This video quickly went viral and sparked controversy and criticism. But this video, incomplete in its scope, does not tell the whole story of the law enforcement encounter with him and arrest of McNeil. It is the officer's body cam worn footage that provides an additional needed context of the circumstances preceding, surrounding, and following McNeil's arrest. Officer Bowers conducted a lawful traffic stop and gave McNeil 12 individual lawful commands, which McNeil refused to obey, repeatedly requesting a supervisor and arguing the merits of this traffic stop did not absolve McNeil from following lawful orders. And this is the point that, in another video I made, right? I know people don't like to hear this, right? But many times, calling for a supervisor, and I get that you want accountability and see if it's systemic, but it's not. But I don't have any statistics about this, but I think that the vast majority of the time, the supervisor is going to get there, and unless the officer is doing something completely egregious, they're going to side with the officers. Take it or love it, take it or leave it, love it or hate it. Another thing that you have to consider is that just because you request a supervisor doesn't mean we stop and freeze the investigation or stop and freeze what we're doing. You can certainly talk to the supervisor, but we're going to continue asking questions, moving people from one area to another. We're going to continue to do what we have to do. And in this case, you got to get people, you want to get this man out of the car. You don't know what's in the car. So while we're waiting for this officer, you could be loading up weapons. You could be doing a whole host of other things. So we're going to continue to do what we need to do in order to bring this resolution to bring it to a successful resolution. Doesn't mean we're going to stop just because you want to supervise. Oh, timeout, big timeout, right? It's not an NFL game. You don't get a timeout, right? So we're going to keep moving forward. Is it true that he was in a car and that he wasn't going anywhere? It's true he could have started a car. They did box him in. It's true that he could have been loading up ammunition that the officers might not have been aware of. There's a lot of things. There's a lot of moving parts the officers have to be considerate of. So, Officers Bowers' use of a one-time open-handed strike to McNeil's face had a legitimate tactical purpose: to get McNeil out of this SUV and to show his hands, which McNeil did after the strike. Officer Bowers' second strike occurred during McNeil's arrest and was in response to McNeil's physical resistance to the arrest. Okay, so you got to be consistent here, right? At one point, he was charged with resisting an officer without violence. What does that mean in Florida? Let's pause this. Okay, so this is the 2024 Florida statutes. This comes from Online Sunshine, leg.state.fl.us. So I'm assuming that this is correct. I don't think that they have anything more. Yeah, they don't have anything else, including 2025 Special Section C. Resisting officer without violence to his or her person. Whoever shall resist, obstruct, or oppose an officer as defined as other places, a member of the Florida Commission of Offender Review or any administrative aide or supervisor employed by the commission, county probation officer, parole or probation supervisor, personnel, yada, 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 legal person, without offering or doing violence to the officer shall be guilty of misdemeanor. So I suppose that, okay, here's the difficulty that we have, people who teach defensive tactics response to resistance, whatever it's called these days, right? So you have all these different parameters, right? You have all these different laws and rules and regulations, and this is the frustration throughout all of law enforcement. However this reads down in Florida can read different in Colorado, different in Texas, different in Connecticut, different in New York, right? And so I did a case. I think I talked about this when I reviewed this before. I did a case about an officer who had been terminated. He's since got his job back, and I was on his side, right? So they're the cities or the towns ordinance, excuse me, not ordinance, the cities or the towns use of force policy, their policy allowed for the use of the officer to use physical force on the same level, and this is what I brought out. It was on the same level as a strike. So if what happened was the officer had used his taser, and the city tried to fire him and saying that it was excessive use of force. Why not use the open hand strike? Why not do something else? So in their use of force policy, the use of a taser was on par, was the same level of force that could be used with a strike. So we look at this particular case, and so it's all about how things are written and all that. And so in this particular case, where this Florida statute is stating that you can offer resistance, you can offer some level of resistance. You can obstruct, oppose, and whatever. But as long as you're not doing damage, or I guess throwing punches, what does it mean to resist and obstruct or oppose as defined? And then you get down here without offering or doing violence. What does it mean to offer violence? That also needs clarification. And so they would probably let's see if we can find that here actually. Okay, so I could not find the actual definition of what it means to do violence, right? So here's another charge: resisting, obstructing, or opposing by offering or doing violence to legally authorized person, police canine, or police horse, right? So you have to define what that means. And so this is the problem. This is the problem when we come into these situations, and what that means. What does it mean to do violence? What does that mean? I mean, is it throwing punches? Is it throwing kicks? Is it trying to run away? I mean, what is, you have to define what that particularly means. And so this is the problem that I think that a lot of us have a lot of times when we're trying to there is no consistent cohesive definition that goes from state to state, county to county, city to city, and from police department to police department. So days after his arrest, so pleaded guilty to resisting an officer without violence, driving on a suspended license. So the question I'm going to have, and I'm going to continue to have, is if you're not doing violence, whatever that would mean, why does that necessitate a strike, a punch? And this is I have a problem with that. If you're not doing violence, right? Let's just say because there's such a thing as active resistance and passive resistance. And again, active resistance, or I would imagine active resistance would be the same thing as violence, has to be defined. And again, the court case that I gave you when the officer was terminated, right? The city, the town had defined, and by that I mean the department policies and procedures. What is active violence? Active violence is, as they put it, was tensing, pushing, pulling, things along those lines. Not just, so if I tense up and I pull away from an officer, that is considered active resistance according to that particular policy. I don't know if that's the same thing that is here in Florida. Is that doing violence? That I'd have to dig a little bit deeper to figure that out. So if he's not doing violence because he wasn't charged with that, does that warrant a strike, open hand, or the punches? That I have an issue with. Right? Bowers conducted a lawful traffic stop in McNeil 12 individual times. Officers Bowers' one-hand strike to McNeil's face had a legitimate tactical purpose. And then, listen, I understand distraction strikes. I understand that. but I don't know about a strike. I mean, I can certainly, put my hand over your eyes to kind of, disorient you, but I'm not going to put my fingers in your eyes. I'm not going to try to cause any damage, right? Just a kind of little flutter. But this man, it was an open hand strike that was audibly heard. I don't understand how I don't agree with letting him get away with that. And I'm not saying that, again, was he digging under his seat and all this other stuff that they try to make it that the article that we read was saying that? I don't see any of that. Officers Bowers strike to get McNeil out of the vehicle and to show his hands, which McNeil did after the strike. Bowers' second strike occurred during McNeil's arrest and was in response to his physical resistance. Was it okay? But his physical resistance. What is that definition of that? And what was he doing to physically resist? What was he doing? Was he actively pushing, pulling, tugging, refusing to go down? And does that deserve a strike? And listen, I'm not saying that I think that he should have been arrested, but I definitely think there should be some type of accountability. There definitely has to be some type of accountability. There has to be some type of disciplinary items that come along with this. I don't know where they're at with this, but I just can't see that. I just can't see that. And yes, I definitely think that the state's attorneys here is not really showing a very good. I mean, they could have just said, "Hey, listen, here's what they could have said. We found that this was unnecessary, but rather than charge him, we're going to lead this up to the discretion of the sheriff's county to employ discipline, right? Because arresting that's just something they could have done and should have done, in my estimation. The facts: just after 4 p.m. on February 19, 2025, McNeil was pulled over in traffic violations by Bowers in the 900 block of West Palm Avenue near Edgewood, Commonwealth Avenues. Officer Bowers observed the vehicle and it parked at a residence, monitoring for drug activity. I don't know if I want to read all this. I want to get to the arrest of McNeil. Okay, we'll get to this part. As a result of refusing to comply with Officer Bowers' lawful orders, Bowers told McNeil he was under arrest for resisting without violence. A second officer, Officer D. Miller, arrived and parked in front of McNeil's vehicle. Officer Bowers warned McNeil that if he did not open the door and exit the vehicle, he intended to break the driver's window. Officer Bowers repeated his warning 2 more times. Bowers then showed his third, fourth, fifth, sixth time to McNeil that he was under arrest for resisting. McNeil did not comply with any of Bowers' orders. After Officer Bowers' repeated commands, Officer Miller walked to the passenger side of the vehicle and asked McNeil to unlock the door and step outside of the vehicle. McNeil refused Officer Miller's request and continued to argue about the traffic stop and ask for a supervisor. Officer Miller's interaction, as an additional responding officer, got on the scene and told Miller that he had planned to break McNeil's window using a window punch tool. Officer Bowers then broke the window and twice commanded McNeil to exit the vehicle and show his hands. McNeil did not comply. Officer Bowers struck McNeil. There's a notation here, number 10. Struck McNeil in the face with an open hand. He struck him. It's not a distraction strike. It's a strike. He struck him and unlocked the door. McNeil was pulled from the vehicle by the officer. McNeil continued to argue with officers and said no and actively resisted. What is that? You got to define that. What does that actively mean to resist? Was he pushing, pulling, tugging, refusing to get down on his knees? Was he given enough opportunity and chance to get down on his knees? When they tried to force him to his knees, did he try to stand back up? You got to be able to articulate and explain what you mean by actively resisting. Officers then took McNeil to the ground, secured his hands behind his back, and gained compliance in about 5 seconds. Search McNeil, the knife. Okay, this is number 10. CJSO interviewer Bowers as to what Bowers described that he could and could not see during the moments leading up to the window break, including McNeil's hands were moving in and out of Officer Bowers' sight. Drug paraphernalia, the McNeil video. McNeil posted a video of the interaction with police on social media. The video was shot from the perspective of the dashboard, looking back to the driver's seat and window. The McNeil video shows 30 seconds before Officer Bowers breaks McNeil's windows, captured a portion of his interaction with the police. It does not include the circumstances giving rise to the arrest or removal of the vehicle, nor does it capture Bowers' commands for McNeil to show his license, registration, and proof of insurance. Officer Bowers repeated his commands to exit the vehicle to be placed under arrest, and McNeil refusal to comply with Officer Bauer's orders. As notable in the McNeil video is the fact that McNeil put it on the seatbelt before filming. And after being advised by Officer Bowers that he had stopped for failure to wear a seatbelt. After, I wonder if this is corroborated. I mean, does McNeil state that, does he acknowledge, trying to think of the charges, right? Does he acknowledge that he wasn't wearing a seatbelt? Because he only pled guilty. He only pled guilty to the to the resisting. He only pled guilty to the resisting, right? Apologies, I had some technical difficulties here. So we're going to continue on. So yes, he was only arrested for resisting without violence and driving while suspended. Well, I'm trying to pick this up. Arrest of McNeil here. His repeated commands as additional responding officers arrived on the scene. Officer Bowers, DB 418, told Officer Miller that he planned to break McNeil's window using a window punch. Officer Bowers then broke the window and twice commanded McNeil to exit the vehicle and show his hands. McNeil did not comply. Officer Bowers struck McNeil in the face with an open hand and unlocked the door through the open window. McNeil was pulled from the vehicle by another officer. McNeil continued to argue with officers, said no, and actively resisted. I went through that, ran down what that would mean. What is it that we're calling active resistance? What is it that we're calling active resistance? How much resistance was it? What was he doing? And all that needs to be elaborated upon. This is obviously just a memoranda or kind of a summary that is given, but again, active resistance is going to mean different things in different jurisdictions. It's unfortunate, but that's the way that law enforcement goes. 18,000 police departments. They all have their own rules, regulations, 50 states, Lord knows how many counties. So it's all going to be a little up in the air to interpretation. Officers took McNeil to the ground, secured his hands behind his back, and gained compliance in about 5 seconds. Does all that actively resisting, does that warrant a punch? I don't think so, in all honesty. I don't think so. Search of the vehicle that determined a knife, drugs, paraphernalia, the McNeil video. On July 20th, McNeil posted a video of his interaction with police on social media. The video was shot from the perspective of a dash cam looking back at driver's seat in the driver's window. The McNeil video began 30 seconds before Officer Bowers breaks McNeil's window and captures a portion of his interaction with police. It does not include the circumstances giving rise to the arrest or the removal from the vehicle, nor does it capture Bowers' commands for McNeil to show his license, registration, and proof of insurance. Officer Bowers repeats his command to exit the vehicle to be placed under arrest, or McNeil's refusal to comply with Bowers' orders. Also notable in the McNeil video is the fact that McNeil put on a seatbelt before filming and after being advised of his arrest. Forgive me if I'm reading all this again because I had some technical difficulties. Officer Bowers broke the window. He again ordered McNeil to exit the vehicle. McNeil did not move. On a second command, Bowers struck McNeil in the face with an open hand. Bowers then told McNeil to show his hands. McNeil complied. The McNeil video then shows McNeil being pulled from the vehicle by officers. Though ordered to the ground, McNeil again refused, yelling no while resisting the officers. Officer Bowers delivers a closed fist punch to McNeil's chin during the takedown. The takedown lasted between 5 and 6 seconds. The remainder of the interaction is obscured from McNeil's camera, but observed through McNeil, others' body-worn cameras. Relevant interviews. Officer Bowers was interviewed on July 21st by JSO Integrity Detectives. Bowers interviewed. The Integrity Unit is a specialized unit within JSO that investigates criminal conduct by JSO personnel. He was accompanied by legal counsel and read his Miranda rights. I don't understand being read Miranda rights. Those are usually involving criminal investigations. Which, I mean, if they're gonna, there's usually two different investigations go on. One of the administrative investigation, that's to determine if any policies and or procedures were violated in the conduct that is in question on this day. The other one is a criminal investigation. That's when anyone, police officers included, are read their Miranda rights. You, depending on his jurisdiction and what their laws and rules are, you don't have to answer those. You don't have, you shouldn't have to answer those, right? It's a criminal investigation. You don't have to incriminate yourself. That's why they're reading them to you. It's the Fifth Amendment. You do not have to incriminate yourself. If the Miranda rights are tied into the administrative investigation, I think that's problematic and probably should be looked at. But he had legal counsel there who would advise him far better than I could do. Far better than I could do. Officer Bowers said he saw McNeil reach for his center console at some point during the time he was instructing McNeil that he was under arrest. Officer Bowers explained he did not know if McNeil had a weapon, did not know McNeil's intentions, and could see McNeil's hands. Officer Bowers said he believed he was at a tactical disadvantage because McNeil had essentially barricaded himself in his car. Officer Bowers told investigators that after he broke the window, he delivered a distractionary blow. Officer Bowers described his distraction strike as a tactic he taught during his time as a narcotics officer when conducting the arrest of the occupant's vehicle. This is an interesting statement because this does not state that he learned his tactics at the police academy or any subsequent training involving use of force. It was just something he learned while he was a narcotics officer. Okay, you might have learned that, but that doesn't mean that it's justified just because you learned it. Who taught it to you? Who said that this was an approved technique? And who told you you did not need to report this on your response to resistance form? Who told you that? Officer Bowers explained that when evaluating how they would remove McNeil from the vehicle, he knew he would need to both unlock the door from the inside and unbuckle McNeil's seatbelt. Officer Bowers stated his intended purpose in using this tactic was not to injure McNeil. That makes the difference because he wasn't intending to injure him, but to distract him so that he could take control of the vehicle. As I mentioned, you can certainly distract. You can certainly distract with a slight glaze or graze across the eyes or something else to get somebody else a focus on it. But that strike was intended to cause pain, and that should have been on the response to resistance at minimum. Whether it was justified or not, I can't see it. I can't see it, but based on his level of compliance, he wasn't actively resisting, he wasn't tensing up and trying to try. He was just kind of sitting there. Now, after the strike, he then puts his hands up as if to give up. So, I mean, that's what we're looking at. I just don't see that level of tactic. And as I'm trying to communicate, depending on how their response to resistance or their response to resistance, departmental rules, regulations, policies, and procedures are written, is a strike equivalent to grabbing someone and pulling them? Are they on the same level? I've told the story already about how one city's policy, the use of a taser, was on par with a strike. Either one is acceptable, and the officer got his job back. So I might know a little bit. When asked why he did not report use of force one in his response to resistance report, Officer Bowers explained he considered his use of the distraction strike, it's a strike, there's the word right there, as a tool. Did not consider a deployment of force. I don't even understand that statement. They just didn't want to arrest this guy. They thought the guy was being a jerk. He was a bad dude. Here's what they thought. Prosecutor, police officers, this dude's a jerk. He's got a knife in the car. He's got drugs on him. We saw him coming from a trap house. We saw this kind of stuff. He didn't want to comply. He's driving around here. It was a good stop as far as, what a time of day. We can argue about it. I'm just telling you that here's their frame of thinking. There was obviously raindrops on the car. At some point in time, within a reasonable amount of time, there was precipitation that had fallen from the sky. He probably saw him with no seatbelt on. Okay. So they stopped him for that. He then guy's a jerk. And now they go through the trouble of breaking his window. He's still not trying to get out the car, and they strike him, and they just didn't want to arrest him. That's just the bottom line. They didn't want to do that. Officer Barr's explanation is credible considering his stated training and the fact that he wrote a response to resistance report memorializing his closed fist punch to McNeil. Also, so the closed fist punch, he reported that, so therefore it's believable what he says after that. Okay. Miller's interview, Williams' statements, misinformation. At the July 23rd and July 29th press conferences, false statements were made and critical facts were omitted. This is kind of surprising for my district attorney. This is kind of surprising, this language here. Specifically, it was stated that officers held McNeil at gunpoint for a mere traffic infraction. This is false. It was after McNeil was under arrest and while officers were attempting to take him into custody that an officer drew his firearm to provide lethal cover to the other officers. It was announced that McNeil provided police his documentation. This is false. It was exactly because McNeil refused to provide his license, proof of insurance, or registration that he was arrested. You have to show it. I don't want to give it to you. I'm going to call a supervisor. You're gonna get your windows broken. You gotta give it to him. Call for the supervisor, state your claim. You gotta give it to him. It was asserted that Officer Barr was made up a reason to justify McNeil's arrest after he was deployed force. This is false. Officer Bowers had already placed McNeil under arrest for resisting an officer without violence before removing McNeil from the vehicle. It was also claimed that there was no evidence in the car. This too is false as outlined above. It was also asserted that that the police, not McNeil, were the ones escalating the matter, but failed to mention that McNeil refused 12 individual unlawful commands from the law enforcement. It was further omitted that McNeil was driving on a suspended license. All of this matters. People don't want it to matter. You don't want it to matter that the people are being bad people and they're doing bad things and they're not driving legally and lawfully. It matters. They're not going to go to bat for you for this type of stuff. I'm still questioning. Believe me, I'm still questioning the level of force that was used. I'm still questioning that. I can't see doing a strike. I can see doing a distraction move as far as a flutter around the eyes. I can see that, but I can't see the strike that was audibly heard. The law, the SAO reviewed this matter to determine whether the use of the force used by Officer Bowers in either Force 1 or Force 2 is subject to criminal prosecution. We have concluded it's not. They don't want to arrest this guy. Officer Bowers conducted a lawful traffic stop and gave McNeil 12 individual lawful commands, which McNeil disobeyed. As a general rule, the decision to stop an automobile is reasonable when the police have probable cause to believe that a traffic violation has occurred. Wren versus U.S. The actual subjective motivation for the individual officer involved is irrelevant and should not factor into an ordinary probable cause Fourth Amendment analysis. In other words, the officer stopped you because you're black and driving in a white neighborhood, or white driving in a black neighborhood, or because you're Hispanic, or because you're a pretty girl. Doesn't matter. Did you violate a law? Was there something that you did that was illegal? Improper turn, turning on a red signal, failing to come to a complete stop at the stop sign, driving in the rain with no headlights on. That's all that matters, is that you did that. Instead, an objective test is used to determine the reasonableness of the stop. Howland v. State. Here, there were a lawful basis for the stop. Some have criticized the de minimis, I hope I'm saying that word right, nature or pretextual nature of the stop, but they fail to understand the applicable law as it relates to traffic stops, particularly in this case. You got to understand that. I know everybody thinks they know more than the prosecutors and then the police, especially the police, but upon his initial encounter with Officer Bowers, McNeil was required to provide his driver's license, vehicle registration, proof of insurance to Bowers by virtue of Florida statute. His refusal to comply with this order, coupled with his refusal to exit the vehicle, gave Bowers probable cause to arrest him for resisting an officer without violence. In Maryland v. Wilson, the United States Supreme Court affirmed that a police officer, as a matter of course, ordered the driver of a lawfully stopped car to exit his vehicle. That's good language right there. Lawfully stopped. What if it's not lawfully stopped? Florida's 5th District of Court of Appeal also addressed the issue in State versus Benjamin, where the court held that a police officer was permitted to order a defendant to exit his vehicle during a valid traffic stop without violating his Fourth Amendment's proscription of reasonable searches and seizures, even if the officer did not have a particular basis to believe the defendant was a threat to the officer's safety. Since the defendant was lawfully detained, Officer Bowers lawfully requested McNeil to exit his vehicle, and McNeil refused. If it's unlawful, you got to argue about that later on in court, not on the side of the road. In light of the aforementioned facts that one, Officer Bowers was trained to use the distraction strike. I'd like to see that training. It's got to be in the policies, procedures, in the training notes of the department, not just maybe something that his training officer used or told him to use when he was an officer in a narcotics unit. He used it in a manner consistent with his training. He used it for the purpose of providing a targeted disruption to allow officers to take McNeil into custody, use force. Use of force 1 does not constitute a criminal act. Officer Bowers' use of force number 2 on McNeil occurred while McNeil was actively physically resisting arrest and while officers were trying to take him into custody. It took officers between 5 to 6 seconds from the moment McNeil was pulled from the driver's seat of the car until he was face down on the ground. During this most singular and fluid moment, several officers attempted to gain control of McNeil from the door of the vehicle until McNeil was on the ground. Bowers stated in his response to resistance report, he struck McNeil in the face with his fist to gain compliance. The report is consistent with the video footage, and with that, Officer Bowers stated in his report regarding McNeil's arrest. It was well established in Florida that a person is not permitted to use physical force to contest even an illegal arrest. You cannot, that's right, you cannot resist any type of arrest. State versus Freeney, citing Meeks versus State, section yada, 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 provides that a person is not justified in the use or threatened use of force to resist an arrest by a lawful law enforcement officer or to resist a law enforcement officer who is engaged in execution of a legal duty if the law enforcement officer was acting in good faith and he or she is known or reasonably appears to be a law enforcement officer. McNeil used physical force to actively resist his arrest contrary to Florida law. So he didn't get down fast enough and therefore warranted the strike because remember, he was charged. There was no second charge. The original charge is, and he wrote it here in the summary somewhere up here, that he was charged. Let's see, it's something, misinformation. Officer Bowers, this is misinformation. Officer Bowers had already placed McNeil under arrest for resisting an officer without violence before removing him from the vehicle. So is this a second charge right here for not getting, he was already under arrest before he exited the vehicle. Now he's resisting again somehow. So either it should have been an escalation or a secondary charge. Maybe they just knocked it down to one count. I don't know. But somehow he used physical force. Again, what does the physical force connotate without violence? What does that mean? Officer Bowers met McNeil's resistance with a fist strike. Is that just? I don't think that's justified. JSO or General Order 551, response to resistance, on April 20th, 2024, speaks to less lethal force similar to what was used in this case and authorizes less lethal force to the degree needed to the effect a lawful arrest and overcome resistance. Again, we got to, this is what this says, the JSO General Order 551. Is that in response to what the state law says? And what does that mean? Less non-violent means. Response to resistance 2024 speaks to less lethal force similar to what was used in this case and authorizes less lethal force to the degree needed to effect a lawful arrest and overcome resistance. I'm not sure about that. I know that's what it says, but what does that mean? I could see through punch for punch. I can't see you trying to wrench somebody's arms behind their back and you start throwing strikes. I just don't see that. Sorry, I just don't see it. Joint locks, pressure points, maybe even OC spray, maybe. But again, is OC spray on the same level as strikes? That's the issue. That's the issue. That's the issue I had in another case. Conclusion: when Officer Bowers stopped the vehicle McNeil was driving, he had no idea who was driving the vehicle. Again, I say that I emphasize that we don't know who's driving the car. Try this for yourself when you're driving around. Try to look into another car that's a couple of lanes over from you and determine if you can see if they're white, black. Are the windows tinted? Are they wearing a seatbelt? Try to do that experiment on your own, let alone try doing that at night. He knew McNeil had just been at a house under surveillance for narcotics. He quickly learned he was dealing with a non-compliant driver. Officer Bowers did not know what was going through McNeil's mind or what McNeil's intentions may be. McNeil, on the other hand, knew he was driving on a suspended license. He knew he had drugs in his pocket and drug paraphernalia in the vehicle. He knew he had a large serrated knife at his feet, and for these reasons, McNeil also knew he would likely be arrested. This past term, United States Supreme Court Justice Kavanaugh, in his concurring opinion, discussed the extreme dangers law enforcement officers face during routine traffic stops. Inordinate risk confronts an officer as he approaches a person seated in an automobile, Pennsylvania versus Mims. That is in part because officers operate in a tactical disadvantage when approaching an unknown vehicle. With limited visibility and predictable threats, unpredictable threats. Brief for National Fraternal Order of Police as amicus curiae for. As this court noted nearly 50 years ago, a significant percentage of murders of police officers occurs when the officers are making traffic stops. That's the Mims case again. Officers cannot let their guard down and assume that any particular traffic stop will be safe, even if the driver is pulled over for nothing more than a speeding violation, broken tail light, or the like. In analyzing the reasonableness of an officer's conduct at a traffic stop, particularly traffic stop where the officer has suddenly pulled away, courts must appreciate the extraordinary dangers and risks facing police officers and the community at large. I think that this statement here is really what sums up the spirit of what has happened in this particular case. You don't want officers turned off and afraid to do their job. This is a common fact. You want officers to do their job. You want them to be confident in the measures that they take are within some standard of reasonableness. And we can question all day whether the strike was legal and justified, but they don't want to arrest this guy. They know that the police officers are dealing with craziness outside. It's an inherently dangerous job. It's an inherent that when pulling over a vehicle that you think is just a simple motor vehicle stop, you as a driver think it's a simple motor vehicle stop. The officer has no idea who or what is in the vehicle that they have stopped and what their intentions are. They might think that this is a routine traffic stop. This person was driving 5 miles over the speed limit. Let me just hurry up and give them this ticket because I got things to do. I got to get back home to get my kid's cookout, a kid's birthday party, whatever. And therefore, all of a sudden, we all seen the videos. It all goes crazy all of a sudden. So this is my thought process as to why they want to charge this guy. McNeil was given 12 orders, which he refused. He created a dangerous situation for himself and law enforcement. Officer Bowers' use of force 1 and 2 were lawful and not subject to criminal prosecution. According to this officer, this office will take no further action. Here is all the stuff that's going on here. Pulling drugs out of his pocket. More stuff on the floor here. There's a knife. And there's the scale that he's doing what he's doing with, right? More stuff here. So, and there's the open hand strike. Okay, let me know your thoughts, your opinions. Do I think that the strikes 1 and 2 were justified? Probably not. But again, it's going to rest on what their level of force is and how it's articulated in their policies. And if a strike is on par with joint locks and wrenching someone's arm behind them, then it would be justified. Would I have acted in this way? Probably not. I probably just would have reached in. I can't see in particular this strike here. I mean, look at his relaxed demeanor as this strike is being given. He's looking forward. To me, he's looking forward and not offering any level of resistance. He has a blank stare in his face, like, "Oh my God, what's up with this?" So I find it problematic, in all honesty. 1 and 2, I find both of them to be problematic. But let me know your thoughts and your opinions. Hit me in the comment section. Much love and peace.